A prosecutor. A crime is a wrong not only against the individual victim but also against the state. Full stop. Therefore, the state take upon itself, at least in case of the serious offense, the responsibility of the prosecuting the accused person. Prosecuting the accused person. Full stop. The central government and each central government central government and each state government have power to appoint prosecutor for conducting prosecution and other criminal proceeding on their behalf in the high court session court over the court of magistrate full stop. So the type of the prosecutor, the court in which they are to work, qualification, the authority by whom they are appointed, and other connected matter. Public prosecutor. Prosecutor हो गया public prosecutor high court advocate in practice for 7 years or more, pointing state government or central central government as the case may be, appointment to be made after the consultation with the high court. After the consultation with the high court, okay, after the consultation with the high court, it has been specially provided that in every trial before a session court, every trial before a session court, it has been specially provided that in every trial before a session court, the prosecution shall be conducted by a public prosecutor. Public prosecutor, whoever no specific provision has been made in the code in respect of the conduct of the prosecution in court of magistrate. In court of magistrate, full stop, prevailing practice in respect of the case initiated on the police report. The prosecution is conducted by the assistant public prosecutor. And in a case initiated on a private complaint, the prosecution is neither conduct by the complaint itself or by this duly authorized counsel. Duly authorized counsel, full stop. In such case, also the state can be appointed prosecutor if the clause has public interest. If the clause has public interest, full stop. The public prosecutor or the AAP in charge of a case may appear and plead without any plead without any हो गया 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 plead. The public prosecutor or the AAP in charge of a case may appear and plead without any written authority before any court in such that the case is dealt with. Further, it has been provided that the advocate general or government advocate or public prosecutor or the AP shall have right to conduct prosecution and that in such a case no permission of magistrate no permission of magistrate no permission of magistrate for conducting the prosecution would be necessary. Full stop. The effect of these provisions seem to be that the public prosecutor over the AP can intervene and assuming the charge of the prosecution even a case initiated on a even a case of the initiated on a private complaint, full stop, where a criminal case is transferred from one state to the another. Where a criminal case is transferred from one state to another, it has been held that the appropriate prosecuting state is the transfer state, and therefore the transfer state cannot be appointed the public prosecutor. public prosecutor, special public prosecutor, neither for the trial or appellate proceeding in a appellate proceeding in a case. Full stop. Azbin and Azerbaijan versus State of Karnataka. It was also observed that a public prosecutor appointed to conduct a case before trial court cannot be deemed to be appointed for the purpose of the appeal arising therefrom. Full stop. The court does not mention about the separate the code does not mention about the separate in which of the prosecutor duty of the prosecutor are to be discharged. Full stop. Whoever the principle in this regard are well settled. Full stop. The Supreme Court has highlighted the importance and nature of the office of the public prosecutor in a Sri Lanka. Sri Lanka Vidyarthi Prasid versus State of UP. State of UP. Full stop. It has been ruled that this is a public office of such importance and that the present spoil system of the appointment to the office of public prosecutor followed by the political party should be done away with. Full stop. Still, there have been cases where the prosecutor over the AAP appear for the accused. Full stop. This practice has been rightly been disapproved disproved by the court. The appointment of the senior police officer as head of this senior. The prosecution agency in the state came to be severely criticized by the judiciary. The prosecution agency in the state come to be severely criticized by the judiciary. Likewise, the practice of the appointing police prosecutor has AAP has also been disapproved by the Supreme Court. Full stop. The duty of the prosecutor in a criminal trial is not merely to show conviction, but to place before the court whatever evidence is in this possession what where it in favor or present the accused to leave it to the court to decide upon all such evidence whether the accused was not guilty of the offense alleged. Full stop. It is not part of the prosecutor duty to obtain conviction by hook over by crook हो गया. The public prosecutor has power to withdraw from the prosecution. The public prosecutor has power to withdraw from the prosecution. The public prosecutor has power to withdraw from the prosecution. Full stop. When a application for withdrawal is filed by the public prosecutor, he has the console responsibility and the low cost in obligation that he would be satisfied in the basis of the material on record, keeping in view certain legal parameter हो गया. Legal parameter. Full stop. Definition of the regular cadre of the prosecuting offer has been expanded by in a inclusive explanation under the section 24 clause 6 section 24 clause 6. Full stop. This has been giving effect to the from 18 December 1978 with a view to the including the officer who have been dealing with the work of the prosecution thought they were not such as called the designation of the prosecutor. Full stop. Apparently, some police officer who have been dealing with the prosecution would now be including as a prosecutor. Full stop. The amended to the The amendment to the code effect in 2005 envisaged the state to establish a director of the prosecution. Directorate of the prosecution consisting of the director of the prosecution and deputy director of the prosecution. Full stop. Advocate having 10-year practice could be appointed as a director or deputy director. Full stop. They would functioning under the home department. Under the home department हो गया. Director of the prosecution shall be in a charge of the directorate. Full stop. All of the prosecutor working at the high court and would work directly under the director. Full stop. The prosecutor including the special prosecutor functioning in the district court and AP would work under the deputy directors who in return would be subordinate to the directors. Full stop. The power and function of the director including the territorial jurisdiction including the territorial jurisdiction including director including the jurisdiction of the deputy director may be specified by the state government by notification. Full stop. It is pertinent to note that the director and deputy director are appointed with the concurrence of the chief justice of the high court. Full stop. This scheme is a departure from the setup originally envisaged under the code of the 1973. Full stop. There is going to be active coordination and cooperation between the police and the prosecution. Theoretically speaking, it may be given the impression of making the independence of the public prosecutor suspension. Full stop. These provisions are not applicable to the Attorney General when he acts as a public prosecutor. The defense counsel, the adversary system, the criminal trial. The adversary system of the criminal trial which we have adopted assume that the state using it investigate resource and employ in a comment prosecutor would prosecute the accused, who in turn will employ in equal competent defense counsel to the challenge the evidence of the prosecution. Full stop. Therefore, both the Constitution of India and the Code confirm on the accused person in right to consult. Defense of the counsel. It may be also noted that the Supreme Court has held that Article 21 of the Constitution implicitly required the state to make in provision for the grant of the free legal service to an accused who is unable to engage of a lawyer on account of the reason such as a poverty. The court, Supreme Court, High Court, Session Court, Court of the Judicial Magistrate, Court of the Judicial Magistrate हो गया, Court of the Judicial Magistrate हो गया, Court of the Judicial Magistrate, Court of the Metropolitan Magistrate, Court of the Metropolitan Magistrate हो गया, Court of the Metropolitan Magistrate, Session Court. The state is to establish a session court for every session division. Full stop. The court is to be presided over by a judge appointed by the High Court. Full stop. The High Court may also be appoint additional session judge. Additional session judge and assistant session judge to exercise the jurisdiction in session court. In assistant session judge is subordinate to the session court. Court of judicial magistrate. Every district, the state government may be consult with the High Court. Consult